Welcome to the Business SOS podcast. This is Rich Sierra, president of the Florida Small Business Legal Center. This is episode 82 of Business SOS podcast. Thank you for listening today. We're excited that you're with us as we continue moving forward to episode 100, which is a very exciting milestone that I'm very getting close to achieving very soon in a few months. Today we have a very, very exciting show for you. We wanted to do this show for a period of time now, and we're going to talk about patents today. And I'm very honored to have a special guest with us. We have John Rizvi. He's known as the patent professor. John is a board-certified patent attorney with over 20 years of experience in patent, trademark, and copyright law. He was among the first attorneys certified by the Florida Bar as an expert in intellectual property law. He has a distinction to represent the highest level of recognition by the Supreme Court of Florida. In addition to his legal practice, John has served as an adjunct professor at Nova Southeastern University at Shepherd Broad Law Center for over 2 decades, teaching courses in intellectual property law. He's also an author, a fellow author as well, of the book is Patent Protection, A Practical Guide for Inventors, an educational audio series that demystifies the patenting process. He's also one of the Inc. 5,000 growing companies. His practice is in Coral Springs, Florida. He practices nationwide. John's practice includes the preparation and prosecution of U.S. and international patent and trademark applications, validity and infringement opinions, licensing agreements, and all aspects of intellectual property litigation. He has earned the AV rating by Martindale-Hubbell, the highest possible distinction, which reflects his ethical standards and professional ability. Today, we're going to dive into the world of patents and explain why they're critical for innovation, the process of obtaining them, and the benefits they bring to inventors and businesses. Before I get started, I forgot to ask you this. Please subscribe to the show. We have this in YouTube as well, YouTube channel, and follow us in Apple Podcasts, Spotify, and wherever you listen to your podcast. So let's get started. John, welcome to the show.
Yeah, thank you, Rich. It's a pleasure to be here.
Okay, so our audience are primarily business owners, and sometimes there's confusion about what patent trademarks are, but today in this episode, I want to talk exclusively about patents. So let's start with the basics. What is a patent?
So a patent is essentially a legal monopoly. And a lot of times people think about monopolies and they think that that's, worry about antitrust and is that permissible? But the patent's a legal monopoly that provides an inventor with an exclusive period of time where they can prevent anybody else from making, using, selling, or importing a competing product. And that limited amount of time is actually not that limited. It's 20 years for a utility patent. And there's another type of patent, a design patent, and that's 14 years.
And why is this important to inventors and businesses?
Well, if you don't, especially if you're a small business or a startup, if you don't protect your idea with a patent, then, and if it's a viable idea and consumers want it and there's demand, it's just going to be a matter of time before competitors start creating something at a lower cost and run you out of business. So it's absolutely critical if you have something that gives you an edge in the marketplace. And you mentioned, that edge could be a new idea. That's what we're going to talk about today, and that's what patents protect. You want to protect that edge so you keep your competitive advantage.
So give me an example of an idea that a business owner could patent. I mean, what is patentable? I think is the question that I wanted to ask.
Yeah, and that's a great question because it's changed over time. And a lot of business owners, their perception is that patents don't apply to us because we're not a high-tech company, for example. For years, when people thought about patents, their thinking was like the movie Back to the Future, like the flux capacitor, and you have the crazy professor with some scientific innovation, or a manufactured gadget of some sort. But business ideas could be a website. It could be a method of doing business that uses a series of steps, that uses technology, and there's no physical product, but it's still patentable subject matter. Compositions, materials, chemical formulas, all of that can be protected And of course, you've got the traditional manufactured product as well. So patents cover all kinds of areas and ideas that go well beyond something that you can hold in your hands or put on a table. Software is patentable. Apps are protectable.
You mentioned earlier two types of patents, utility and design patents. What is the difference?
So the utility protects the function of a new product or idea. The design patent protects just the way it looks. An example could be, say you have a unique belt buckle that someone designs. What this belt buckle does is automatically expands or contracts as needed, so you don't have to adjust it. So you have a heavy Thanksgiving meal or something, the belt buckle will automatically loosen up.
I use those. I have those.
I made that example up. So
I have one.
Phenomenal. But if that's your idea, you want to get a utility patent to protect that function, because if you get a design patent, all you're going to protect is the exact look of the exact buckle you have. And if a competitor likes this automatic expanding and retracting feature, takes the heart of your invention, and if your belt buckle just is star-shaped, for example, and they make it square, and all you have is a design patent, they get around your rights because they've taken the look. So the utility patent protects the function. Now, if your belt buckle is unique because that shape is what everybody wants, then you want to protect it with a design patent. So you protect the look. A lot of products, you need both because the look's unique and you want to protect that look of the idea, but you also find something practical that your invention does that no one else is doing. So you get a utility patent. The iPhone, for example, is a great example. Apple has design patents protecting the look of the iPhone, the shape, and they also have utility patents protecting its unique features that separate it from other phones.
What is the process or the question, how difficult it is to obtain a patent? And I'm doing a very broad question. Probably can break it down a little bit more.
Yeah, so I'll go over the process first.
Okay.
And the difficulty, I'll just give you it's really difficult. It's a long process, but you start with a patent search, and you need to have that done by a registered patent attorney, because this is not a search of just public documents or Google or online. This is a search of the U.S. Patent Office database, and it's done not just based on language, because language is not precise. What one person calls a hose, somebody else will call a pipe, for example. So when we have at my law firm 4 former patent office examiners that used to work at the patent office, and so they're specialized in searching, and they search based on categories. So regardless of what language is used in a patent application, if they'll go to the proper class and subclass and search everything. So it starts with the search. If you go to see a patent attorney, that search usually takes about 7 to 10 business days, and you get results. You can think of the search as like an X-ray before an operation. The X-ray advises the doctor, or in this case, the patent search advises an attorney whether your idea is unique enough to justify proceeding with.
You mentioned registered patent attorney. How does an attorney become registered with the USPTO as a patent attorney?
Yeah, so patent law is a little bit unique in that there's no state-based patent law. There's no such thing as a Florida patent office or a New York patent office or California patent office. There's the U.S. patent office. So in addition to a lawyer becoming licensed in at least one state, it doesn't matter which one because patent law is federal, then you have to also pass an exam given by the U.S. Patent Office. And when you pass that exam, and then they also require a technical, typically an engineering background, so that you can understand technology and new inventions. So you've got to first go to engineering school, become an engineer, then go to law school, become a lawyer, then pass your state bar, and then pass this federal bar. So talking about the patent process being difficult, becoming a patent attorney is also a huge journey.
Okay. In your office, obviously, you're a registered patent attorney as well.
Yes.
Okay. What are the steps you were talking? You told me the first step to obtain a patent is the patent search. What is the next step after that?
Yeah. So the real value of the patent search comes from the advice that you receive based on it. It's just like an X-ray. If you're not a doctor, receiving a copy of the X-ray is not what you really want. What you want is somebody with judgment and experience to look at your X-ray and diagnose what you need. So once the patent search is done, you want to speak to either a patent attorney, or in our case, at our firm, we have former patent examiners who used to work at the patent office, and their job was to decide which ideas are granted or denied. And they'll meet with inventors, go over the patent search, and advise them about the likelihood of success in actually getting a patent. And if it's not a high likelihood, then they will advise you not to proceed, and then you don't go past the search. Now, if it does look like you have patentable subject matter, then the next step is to start a patent application.
I've heard of a term called provisional patent application. What is that?
So I can't say new anymore. I've been practicing, almost 30 years. But in 1995,
you started when you were 15?
Thank you, Rich. Not quite, but so until 1995, there was one type of patent, and it was a non-provisional patent. Those are incredibly complicated and expensive, and they require a set of numbered paragraphs at the end that determine how broad or narrow the protection is. And because that's so time-consuming to prepare those paragraphs, they're referred to as claims. In 1995, the Patent Office permitted a new type of patent that is a temporary patent that gives you protection for 1 year, and that's known as a provisional patent. It's a great route for business owners and individual inventors to temporarily protect their idea while they test the market, see if there's demand, maybe speak to investors. And then at the end of before the expiration of 1 year, if they believe they're really onto something valuable, then they can pay to have the claims drafted and then convert it into a non-provisional, which is the final patent. So it's a great avenue because it lets you kind of dip your toes in the water before investing all the way in a full patent.
Does it provide protection to that first year?
Yes. Yep. You have a secure filing date with your provisional patent, and then once it's filed and patent pending, then you can start offering your product publicly. You can sell it. You no longer have to keep it confidential.
Okay. So that's a good placeholder.
Exactly. That's a great way to think of it.
Okay. What are the challenges your investors faced? Well, let me ask you this: what is the next step after that? I'm kind of skipping steps here.
Okay, so you've done your patent search.
Yes.
You had the meeting with at our firm, one of the former examiners from the patent office. If they give you a green light, then you're ready to start the process. We'll send out an agreement to start, and at my firm, we work on a flat fee basis, so there's no hourly charges or surprises. You get your flat fee. You sign off, and then the process of drafting the application takes place. And that takes about 12 weeks. And what the Patent Office requires is a detailed description of showing how somebody can make and use the invention. So a lot of times it almost always requires detailed drawings of the idea. If it's software or an app, then instead of physical drawings of components, you'd have a flow chart kind of showing the different steps. And that process takes about 4 weeks, 3 to 4 weeks while the drawings are being done by our illustration team. The attorneys are working on the background of the invention and the field of the invention. The purpose of this part of the patent is to place the examiner in the shoes of a potential purchaser of this product and try to show the examiner why there's a need for it and why it's better than everything else that's out there.
Okay. So after that, then how long does the process takes from the application all the way to approval or rejection, or what happens?
Yeah, perfect. So 12 weeks later, the application's done. given to the inventor for approval, and we file. Now begins the long wait for a decision. Now, if it's a provisional patent, then you have 1 year where it's a placeholder, where there's nobody at the patent office that's going to make an official decision. Now, let's assume that 1 year is up, and then you file the non-provisional patent. Now you're in queue for a decision, and it typically takes another 18 months after that. Could be sooner. I've seen them as early as 7 or 8 months, and usually a year to 18 months later, you'll get a decision from the patent office on an allowance or denial. 99.9% of the time, the first decision is a denial. But what makes patent law different is that's not a final decision. So I think of it as a soft denial, and the examiner's then waiting for your response on what, typically he'll come back with what he thinks is already showing your invention. So he'll do a patent search of their own, separate from what your attorney's done, and then say, okay, I don't think your idea is patentable because I found X, Y, and Z. And now it's up to the inventor and their attorney to review patents X, Y, and Z and explain to the examiner why their idea is different and unique. And if you've done your patent search at the beginning, your attorney would have already known about X, Y, and Z. And then they're well prepared to explain why the invention should still be patentable.
Okay. Is that what is called the prosecution period?
Exactly.
Okay.
And that's typically anywhere from 1 to 3 years. It's known as a prosecution period because it's usually 2 or 3 denials, and each one kind of illustrates the examiner's position and gives the inventor a chance to push back with their attorney's help on why the idea is really different than what the examiner's found.
During the application period, is that idea protected?
Yes. During the entire patent pending period, you have your firm filing date, and anybody else that happens to file is out of luck because you've got the earliest filing date. So business owners might be worried thinking that, gosh, 18 months sounds like a lot of time. And while I'm waiting, what if somebody rushes forward and files first? Well, that first filing protects you. Now, if they don't file and they start selling product, now you're in a difficult position because you don't have the patent granted yet. So you can't sue for infringement. They're technically not violating your granted patent. But a lot of times a cease and desist letter that puts a competing company on notice that you have a patent pending is all it takes to get them to withdraw their products.
Okay. What are the common reasons, or the most common reasons why the USPTO will reject the initial patent application?
So typically there's 2 statutory bases for a rejection, and it's a 35 USC 102 is one section that essentially is the examiner saying your invention already exists. Now, if you get what's known as a Section 102 rejection, the examiner believes that your exact idea has already been patented. And those are a lot harder rejections to overcome, because if the examiner is right and your exact invention is already patented, there's a limit to what you can argue. If you find differences, and the easier rejection to overcome is a Section 103, which is the known as an obviousness rejection, which is the examiner admitting that your idea is not out there. So admitting that you have something new, but taking the position that what you have is an obvious variation of what's already out there. So he's like, yes, you're right. This is not the exact invention, but I don't think it's enough of a leap to go from the idea I found already patented to what you're doing. And those involve a lot of discretion, and there's room for argument because it's a matter of judgment, and opinions might vary on what's different enough. For business owners, they're looking maybe for some hardline examples of what's not different enough. So I'll give a couple. One is size. So if all you're doing is changing the size of something, that's typically not patentable unless changing the size is overcoming some obstacle, like nobody else has been able to. A great example is a hearing aid. There's a time when hearing aids were so large that they were visible because they couldn't make them small enough. So now if someone figures out a way to make a hearing aid small enough that it's so far into the ear it doesn't show, they've overcome an obstacle. So with every rule, there's an exception. So typically size is not enough. Color is not patentable. And generally shape is not patentable. Again, if you're overcoming some obstacle that nobody else has been able to do, then color and shape and size can all be patentable distinctions.
Yeah. So after that initial rejection, and then you basically, the examiner writes, I guess, the response. What happens next?
Yeah. So once the examiner sends their, it's known as an office action, which is then an opportunity for the inventor to review that decision along with their attorney and respond. And you typically have 3 months to file a response, either arguing with the examiner that what they found is not your invention, or changing the claims of your invention, narrowing what you're seeking to distinguish what you have from what the examiner cited against you.
This is all done through, I guess, paper pleadings or electronic pleadings. Is there a situation where you have to have oral arguments, or is this all through the documents that you submit?
Yeah, so you do have to submit a written argument, but then you can request an examiner interview. So in addition to the documents, you can also have an oral argument where you make your case. The examiners have discretion to allow or deny a request for an oral argument. And almost always, if they do agree to it, they are also going to require you to submit your proposed arguments prior to the oral argument. Now, those are almost always done by telephone and not in person.
Okay. You mentioned earlier that those initial, the common initial rejections you have, which comes back to the importance of having the proper patent search done by a registered patent attorney, and then the advice that you receive is critical. Because you can have, if you don't have the proper patent search, I would imagine, and then you don't have the proper advice, you can end up applying for a patent and end up wasting your money.
Exactly. So what you pay for with the patent search is really the advice. And I point that out because there's a lot of services online now that are offering patent search results. And what you'll end up getting as a business owner is a stack of documents with not really a legal opinion. And that's not valuable. That's like, as a patient, if you're just mailed an x-ray and you got to look at it and figure out, do you get the pacemaker or not? Well, you don't know. What's really valuable is a doctor explaining the x-ray. And that's why you want to be careful about not just where you get your search results, but who you're meeting with to go over the results.
I think this ties into my next question, why it is not a good idea for inventors to handle their own patent application.
Even as an experienced patent attorney, it's typically takes years, 5 or 6 years, being mentored by an even more experienced attorney before you really learn what types of arguments are successful at the patent office and which ones are not going to be weighed heavily. Some things that a lot of my clients point out and business owners generally look at this as distinguishing their idea. They'll look at cost perhaps and say, nobody can do what I'm doing at this cost. Now, an experienced patent attorney will tell you that the patent office typically does not care about the economic advantages of a product, because in a free market, the free market's going to reward a business that can do something faster, cheaper, or better.
Yeah.
What they're looking for is a technical structural difference. So that's an example of where a non-attorney would make an argument that really holds no weight.
How can patents attract an investor to enhance their business competitive advantage? I mean, how can a business owner utilize a patent to perhaps attract investors to that business?
So what an investor is looking for, a return on their investment. And if you have a potential idea that you invest in, and you buy rights to do something that an inventor brings to you, what you would want is some kind of assurance that others are not able to do for free what you've paid for. So the patent is the only way that you have any assurance that your investment is protected, and that you might be first to market, and whoever's first to market like has a temporary advantage. But if you're up against a big competitor with the resources to sell an equivalent product cheaper, then that first to market advantage is quickly going to erode, and you'll, as an investor, you'll lose out.
Yeah, but also they want some security as well. I mean, if you have an idea and it's not patented, trying to get investors can be difficult.
Yeah. Oh, it's incredibly difficult. And if those of you that like, and this has become so clear after shows like Shark Tank and American Inventor have gone online. Like, typically the sharks always ask before investing, is your idea protected? Is it patented? Because they want to know that if they put their money into this, that you really have, that you're selling them something that you have ownership of. And if you haven't patented it, you have no ownership to that idea, and that substantially reduces the value of what you're selling.
Say an investor is successful. The process after that will be getting the patent or getting the final rejection in terms of the sequence of events. So say inventor gets the patent. How can inventor monetize that patent? That's kind of a broad question. And I'm going into whether it's licensing it, selling it, does that become kind of something you can monetize at some point?
Yeah. So once you get the patent granted, what you have is essentially the right to prevent anybody else from making, using, or selling it. Now you have the right to prevent anybody else, but you could also permit somebody to make it, use it, or sell it. And that's what you're getting at with licensing. And that's what licensing is. Licensing is saying nobody is allowed to make this except you. And I'll give you exclusive rights, which is one type of license to do it. And you are not going to be seen as an infringer. And when you license, you typically, there's different ways that you can monetize it. The most common is as a percentage of sales. Sometimes it's a per unit cost. The other way is you sell the patent outright, and you're saying, I'm not going to give you a limited license to use it. I'm going to sell the entire patent to you, and you own it. Downside of that is then the inventor, no matter how much money the potential licensee makes, it's none of your business, and you have no rights to those because you've sold the full patent. So licensing gives you a share of the upside because you get a percentage of sales. So the more the product sells, the more you make.
Okay, that is great. Can you share with us a success story of a business that patented and benefited investor or business?
Yeah. So, we have several, but perhaps one of the biggest success stories we have was a Coral Springs business, an individual inventor. His name is Alex Gomez, and he was a medical resident that realized that the surgical lenses on doctors' instruments were getting fogged in the operating room, and doctors were removing the surgical instrument and either rinsing the lens off or under a faucet, or dipping it inside a beaker of water and then going back inside the patient.
It's very, very concerning, but go ahead.
Yeah.
It's another podcast on that one.
Yeah. It was concerning to Alex because it went against everything he was taught in medical school. Like the surgery is, this introduces, bacteria, and it's septic. And, as fellow lawyers, we know what lawyers have done to protect doctors in hospitals is we have waivers of that patients sign saying that all surgeries involve risk, and therefore there's a risk. But this Alex was not happy with that. He's like, there's a way to prevent this. And he created a surgical lens defogger that he patented and was able to sell to Medtronic for $100 million. And there's no way, as I mentioned, as you asked before, why would an investor invest unless it's protected? The patent is what gave them the assurance they needed that they would not have competitors to this product if they spent time and money in R&D and investing in it.
That is a great story. I mean, he found something he just realized that was needed. Mm-hmm. He took action about actually going further and getting the patent. A lot of people have ideas and they say, well, I'm not going to do it. And then they see it later.
Right. Yep.
So if somebody has an idea, it's worth a phone call.
Oh, absolutely. And, and the biggest thing I think stopping inventors is this fear that they're not the right person. They don't have, Alex at that point he wasn't a doctor. In fact, he dropped out of medical school to pursue this idea. And ironically, has ended up doing more for the benefit of patients and medical health than he ever could as an individual doctor. But it's important for inventors not to think that because they're outside an industry that they can't change that industry. I mean, look at what Elon Musk has done with Tesla and electric vehicles. Like, where was Ford and GM and Chrysler and these companies with billions of dollars of federal taxpayer help plus 100 years of time advantage, and yet this individual owner of PayPal has done more to bring electric vehicles to the market than established car manufacturers. So
that is true.
So don't look at, okay, where am I and who am I to bring this idea to market? If your idea is good and it provides an advantage, get it patented, because the patent's going to give you a monopoly that prevents anybody else from competing with you, and that will give you what you need to go to investors and get investors. Or if you have the capability of, and today a lot of products are digital products, software, you no longer have to be Ford or GM to bring a new product to market. You could be an individual working out of a spare bedroom and create the software that if you get it patented, it could end up becoming a multi-million-dollar product. Yeah.
So I guess I was going to ask you what advice you can give to business owners that have an idea. I mean, we're going to have a few more minutes. How can people reach you as well?
Yeah. So as far as and I'll be quick in terms of the advice. The most important thing is to keep that idea confidential until you speak with a patent attorney. It's very tempting as a business owner because that's how business is done. You want to test the market. You want to see are you really onto something. So you want to speak to your existing customers. There's this temptation to speak to other experts and get their opinion. Resist that temptation because your idea is not protected yet. And the patent office is on a first to file basis. Whoever files first owns the idea.
Wow, I didn't know that. Okay.
Don't talk about the idea. Go see a patent attorney. That's the most critical piece of advice. Now, as far as reaching my firm, my law firm is The Patent Professor. Our website's thepatentprofessor.com. But anybody that's on any social media, TikTok, Facebook, Instagram, our handle is The Patent Professor as well. So type that in and you'll find us.
Some of our listeners may have an idea, and do you offer free consultations?
We do. If you call our office, we actually have free consultations with former patent office examiners. So there's no charge. If you have a new idea, you can speak to a former examiner and get an understanding of whether your idea is even potentially the subject matter of a patent. So for business owners, if you're not sure, there's really no reason not to take that first step and find out if your idea is protectable before you reveal it to anybody.
Yeah, and the information they provide to you is attorney-client communication as well.
It's completely attorney-client privileged and 100% confidential.
Even though you're in Coral Springs, that's your headquarters, you work nationwide.
We do. In fact, only less than maybe 2% of our clients are in Coral Springs or even in Florida. Like, we have clients all over the country because patent law is federal. And most of the consultations are just by phone or now Zoom calls or video conference calls. It's almost, even our local clients rarely come to our office for a meeting. So patent law is federal. So no matter where your listeners are, if they have a new idea, we can help them with it.
Okay. And they can call pretty much from all over the country. I notice your hours are almost 24. Anybody can call you at any time.
Yeah, because unfortunately, ideas don't come between 9 and 5 on weekdays. So if you have an idea, call our office. We can arrange for a consultation. Certainly, if you don't want to reveal the idea until you have that initial consultation, just to find out if it's protectable. And when you speak to us, everything you discuss is attorney-client privileged.
And the website is thepatentprofessor.com.
Exactly.
Yeah. Well, John, thank you for coming in today. We're excited. You have a few more minutes till we can talk the next segment as well.
Perfect.
We're going to talk about trademarks, copyrights, and a little bit about more intellectual property as well, and trade secrets, maybe patents as well. But we cover a great deal of topic today in patents. Hope you enjoyed today's episode. Again, if you like the podcast, please ask you to subscribe to our show. You can follow us in Apple Podcast, Spotify. We're actually in iHeartRadio, and we have the podcast also on our YouTube channel, which is at youtube.com/@Richard Sierra. You can see the video and also the audios are posted as well. You can listen to them as well. If you're interested in our legal services, my website is FloridaSmallBusinessLegalCenter.com. Again, it's FloridaSmallBusinessLegalCenter.com. And you can send me an email at rich@richsierra.com. And you can also call us at 166-842-5202. And we'll have all this information in our show notes, including John's website as well. Again, thank you for listening. Until next week, this is Rich Sierra, and my goal is to help you succeed.